day in and day out, we faced all these problems over a period of about 35 years of service, and definitely we feel that whatever that is to be suggested at appropriate forms like this, it is our bound and responsibility to do so. So that way, today I would like to concentrate on these 2 points, that is mineral concessions, especially on mineral concessions, but for this environmental clearances and forest clearances, only I will offer my opinions also. But as far as mineral concessions are concerned, everybody's concern is delays. See, this Huda committee was constituted only with a reason that the GDP is falling in India. Why? Let there be a committee to see that the problems in mining sector are solved and some remedial measures are taken to see that problems are reduced. But after seeing Huda committee report and after seeing the new MMNRD Act, it is 80% more complicated than the existing Act. Confidently I can say that, because whatever simple procedures that were laid right from 1957, wherever there are some defects, we have brought in the form of amendments. Maybe by bringing few amendments, the existing Mines and Minerals Regulation and Development Act 1957 serves excellently with all the amendments brought out, and if they solve the problems, some of the problems we are facing. But if you see the new Act, it needs a professor must be administrator. We must keep a professor so that he will follow meticulously in the word by word, whatever there in the Act, a professor may follow, but it is very difficult to implement for administrator. If new Act is coming means lot of cases, because a particular section, the interpretation of the section differs from person to person. It will be deferred for an officer, it will be deferred for the leaseholder, and ultimately it will be deferred for an investigating agency. I think the cases will also improve by way of if we implement that new Act. Fortunately, the last Parliament did not pass it. I hope the dynamic Prime Minister Modi will definitely go into in detail, and it is our responsibility to apprise him properly about the defects in the new Act. Now, if we see the applications present system, the major minerals, first schedule minerals, atomic minerals and other minerals, we had the different procedures, and as far as first schedule minerals are concerned, Government of India's approval is essential. Therefore, the tiers are, one more tier is there up to Government of India. Atomic minerals also same, and for other minerals only, like say minerals like quartz, feldspar, etc., state government can take decisions. See, in Andhra Pradesh, as far as Andhra Pradesh is concerned, the various tiers to process the applications right from district level authority, that is assistant director, it goes to joint director, then secretariat, from there Minister of Mines, Government of India. All these authorities have to give clearances, and then apart from that, before sending the files to all these authorities, the clearances from other departments like district collector, district forest officer, in case it is a forest land, and then at state level principal CCF, and then Minister of Forest and Environment, and at central level Indian Bureau of Mines, Minister of Forest and Environment, and environmental clearances. These are all the cumbersome process we need to get a mining license. And if we follow all these routes, I think presently if we take time, if we take the time count, the average period that is taken for grant of a mining license in Andhra Pradesh or in India, we can say maybe beyond 3 years. Beyond 3 years. Definitely there are some cases where 10 years, beyond 10 years also leases are not granted, but minimum period taken is 3 years. This time limit disposal as per section, as per rule 63 of MC rules prescribed for RPC is 3 months, and for PL 9 months, and for ML 24 months. But very rarely this time limit is adhered to, and everybody knows about it. Then what are the proposed changes in the new MMNRD Act? See, this is the existing Act, and what are the problems we are facing in the existing Act? They did not properly understood, and simply they have taken totally radical changes in the new Act. Just I would like to present before you few. Approval of GOA for first schedule minerals dispensed with except for coal and atomic minerals. This is the only best part of that new act because they have dispensed with the clearances from Government of India except for coal and atomic minerals. We have to appreciate for this. Then eligibility criteria. Actually, in the new previous act, a citizen of India or a company, if it is a company, Indian company, is eligible to apply for a mining lease. In olden days, there was a provision to obtain certificate of approval to file an application. Now that was dispensed with because that is not, our experience revealed that it is not necessary. But again they have introduced this here. You see, the IBM, applicants must register with IBM for applying any mineral concessions for major minerals. What for this? I feel that totally this, the plane has been hijacked by IBM to just have more powers, more and more powers in the new act. I don't hesitate to comment that way. Otherwise, why applicant must go to IBM and register for filing application? He is already filing application. It means that he is coming for getting a license. Why should again he register for filing application? He has to register. You look, IBM offices are located at headquarters like Hyderabad or state headquarters, whereas applicants can file applications at district level. We have to think of spreading to mandal levels or division levels. This is the state of affairs, whereas we are again centralizing instead of decentralizing. Then, by introducing the old system of obtaining certificate of approval before filing for any applications is again restored. Time-tested and dispensed with procedures are reintroduced. Will this amount to efforts to minimize the delays? That is my question. Then additionality in new act. See, already we are fed up with getting clearances from various departments. Now one more department is added. That department is obtaining the clearance from district panchayat officer, DPO, is additional requirement for grant of mining lease under new act. See, DPO is subordinate to district collector. When district collector gives clearance, why again DPO clearance is required? I don't know how this has happened. Then time limits for disposal of applications under new act is very attractive. If issue at it, it is very attractive. RP 3 months, large area prospecting license 3 months, ML, letter of intent 3 months. They give a letter of intent simply. Afterwards, it is the funeral of the applicant to get forest clearances, this and that. Ultimately, it may take 4 to 5 years also, but at least to some extent this is good. But there is one more provision, that is notification of areas, and the notification, almost all the areas have to be notified for grant wherever investigations have been completed by including a clause of financial bid. Then I thought this financial bid is for mineral potentiality, but it is not for mineral potentiality. It is only for the expenditure incurred by the state government for conducting mineral investigations. They wanted to recover the expenditure incurred by the state government for conducting mineral investigations. To that extent, they wanted to recover that amount. Therefore, that financial bid. That is not for everybody. Is under the impression that leases are being actioned under the provisions of new act. That is not correct. Only for coal that provision has been introduced. That too with the exception that for public sector undertakings it is not required, and for companies who are having power projects that is not necessary. Almost there also it is diluted, but apart from that I have my own reservations. If mineral deposits are put to public action, ultimately, see, anybody, a Reliance industry can completely contest, and for entire India they can take. Is it, if we are getting some X amount of tax, if somebody comes and bid for X plus Y, is it we are going to give right of collection of tax to some privater? Somehow this concept also not correct, and existing principle of collecting some royalty fixed by the Government of India is excellent, and I don't know why people are tempting for auctions. If you put auctions, a coal deposit, a ton of coal may cost 5,000 rupees, but how is that person is recovering? He will definitely put on consumer. Ultimately, who has to bear the burden of this additionality? on way of competitive bidding. Who will bid for competition? Only rich people. And there is no question of coming up small people in mining field. Completely they are eliminating the small mine owners into field of mining. That is the essence of this act.